Supreme Court has rejected centre's objections and has allowed the hearing in petitions challenging provisions of Money Laundering Act. These are review pleas challenging the Supreme Court's order on the powers of Enforcement Directorate. Now remember, the top court had upheld ED's stringent powers, which allows the central agency to arrest, seize and search without warrant. Now, the next hearing on the review plea is lined up for November 22nd. What I'll do, I'll go across to my colleague Arvind, but very quickly before doing that, let's just very quickly tell you what are the powers of Enforcement Directorate, which are under the scanner of the court. In fact, the special powers to arrest, seize, search without warrant. Statement made during interrogation can be evidence in the court. No need to provide case information copy to the accused. The accused has to prove innocence. ED does not has to prove guilt. So the onus is on the accused, not on the Enforcement Directorate. The PMLA can be applied retrospectively as well. Arvind, these are some very, very stringent, norms as far as the PMLA and the powers of ED is concerned. Repeatedly being questioned, not only by activists, but also by the opposition parties in the country. What is the significance of this hearing?
Ankit, at the outset, let me make one point very clear. This is not the review plea that has been filed challenging the Vijay Madanlal Chaudhary judgment that was given by the Supreme Court in 2022. So that particular review plea challenging the overall judgment that had upheld the several stringent provisions of PMLA is pending before a different bench. But this is a completely different plea. Almost at least 3 or 4 petitions have been admitted by the Supreme Court today, and all these 4 petitions are challenging some of the provisions in PMLA that has already been upheld by the Supreme Court in a different judgment. So today, that was a primary objection from the centre side. Today, Solicitor General Tushar Mehta, appearing on behalf of centre, in fact, raised the same objection, saying that when there is an 3-judge bench judgment that has already upheld the provisions of PMLA, another coordinate bench of same strength, that is the 3 other judges, cannot go into the same validity of those sections that have already been upheld by the coordinated bench or by the bench of same strength. And that seems to be the prima facie objection on the maintainability by the centre side. But today Supreme Court rejected the objections of the centre, and then they have proceeded to go ahead with the hearing. In fact, Supreme Court has said that 4 of the petitions will be taken up for hearing. And then in these 4 petitions, there are some 6 provisions that have been challenged. Validity of these 6 provisions under PMLA have been challenged by the petitioners. One, like you mentioned, Section 50 of PMLA, that is any statement that has been given before the ED officer is admissible, is an admissible evidence in court of law. That Section 50, along with Section 3, which deals with the definition of money laundering, along with the schedule offences that have been listed as part of Money Laundering Act, along with, very importantly, the twin conditions that have to be satisfied by the accused in order to secure bail in money laundering case. These are the important provisions that have been challenged in these 4 petitions. So today Supreme Court has admitted all these 4 petitions, and Supreme Court has said that they will go ahead with the hearing, and then a centre can also raise the objection, or centre can also continue to raise the argument on the maintainability of all these petitions, saying that because these provisions have already been settled by a different bench, this particular 3-judge bench cannot go into this matter. Is something that the centre can still argue in the next year of hearing, which has been scheduled on November 22nd. But Supreme Court, in a historic way, Supreme Court has said that they will look into the constitutional validity of these important provisions of PMLA. So on the next date of hearing on 22nd, the petitioners will be challenging the validity of these sections, whereas the centre will be questioning the maintainability of this case. And if at all the Supreme Court finds that this particular matter has to be dealt, the constitutional validity of these provisions have to be heard, then this particular matter will be referred to a constitution bench, and the constitution bench will take a final call whether to review the 3-judge bench that has already given judgment on this matter.
Arvind, thank you for sharing these insights with us. A very, very important case because, ladies and gentlemen, you keep hearing the Enforcement Directorate, at a very high frequency these days as far as the news cycle is concerned.